Your Honour.
Where are we up to?
Oh, you're still with me, I'm afraid, Your Honour. That's what it is. And Mr. Porter as well, so it's a bit more emphatic yesterday again.
That's all right.
Thank you.
I liked that comment though by Miss Little. No data is no defence.
Yep.
And I think that
Excellent.
could be quite applicable to body-worn video and assessments of uses of force.
Well, let's, since Your Honour's raised that, Mr. Porter, let's deal with it. There's clearly an issue in relation to the usage of body-worn video, particularly by Mr. Rolfe during the 2017 to 2019 period. Is that right?
Yes, that's correct.
Now, what's the police force doing to make sure that people turn on their body-worn video and deal with it properly?
As I said previously, my evidence, especially when it comes to use of force, we now have it all assessed by, well, we put in places to increase the compliance by supervisors, as well as escalated to senior sergeants to review all use of force incidents, which they had to take into account body-worn video. Also, we implemented or commenced our SME position out at the college to
Subject matter expert?
Subject matter expert position at the college to review or undertake review of all use of force incidents, which they then, if there's any non-compliance, gets reported through to the Professional Standards Command, as well as that there's been a number of broadcasts sent out in relation to body-worn video and compliance. Also, with any complaint against police matters, we actually have implemented in the IOPRO system for any matter, irrespective of whether it be use of force or any other complaint, of whether body-worn video was activated or not activated, or if it was even applicable in the circumstances, which gets also monitored by PSC, and then we then take appropriate action whenever it's identified that body-worn hasn't been undertaken.
Let's go to the data question that Her Honour was raising.
Yes.
When was body-worn video introduced into the force?
Be around 2015, somewhere around there.
All right. Is it fair to say that there was some level of controversy and a degree of non-compliance in the early phase after its introduction?
Yes, there was, and there's also only very limited rollout at that point in time because of financial constraints.
Yeah. Just availability of the technology generally.
Yes.
Right.
It's a new concept to the agency.
It was. So what do you know today as to levels of non-compliance with the obligation to switch on body-worn video when an officer is operational in any given scenario?
It's not a predominant matter anymore.
Now, how do you know that?
Because of the complaints that come in.
Right. Talk in terms of data, if you would, so
Yes.
Her Honour understands. I'm not asking in numbers, but just to give Her Honour a flavour of whether this issue to do with the use of body-worn video is being monitored and what the trends are.
Yep. So when it comes in, as I stated in IPRO, it is flagged about body-worn video. It's a specific field, and we run reports. And I don't know, I can't give you data of how many, because of that. Because every incident you go to, you could have 5 or 6 members at one incident. So it's multiple activations. So we actually run reports against IA Pro, which will indicate if they've had previous non-activation or not. And then, like I said, we deal with it then appropriately.
If you were asked to, could you identify the numbers of occasions when it has come to the attention of the force, say last year, that body-worn video was not operative when it should have been?
Yes, we can run that report.
All right. So the data exist?
The data exists.
Your Honour, would you like them?
Sure.
I'm not urging you to take them. There are only so many things which should occupy your time.
Well,
But-
it did just arise in Miss Little's evidence as well about the fact that complaints are sometimes not lodged because people don't feel there'll be an adequate response, and part of that is because they're aware that there's been no video recording, and it seems that those complaints go nowhere.
Well, it's certainly a crucial part of information, possibly the most important piece of information about what takes place in an incident, because it's objective.
And when it's word against word, it seems that the police are not prepared to accept the word of a complainant as opposed to a police officer. And that's why I suggested that no data, no defence might be an appropriate response, where police have the capacity to record interactions and where they're directed to do so. A failure to record those interactions, particularly in light of a complaint, whether or not it amounts to no data, no defence, it should certainly be viewed as a very serious failure to comply with the operational requirements of a police officer. In the same way, when someone doesn't blow into the breath test, fail to give breath equals a high range drink drive.
That's correct.
For the penalty. It's the same sort of failure to record an incident should have the same sort of level of seriousness. I'm not suggesting across the board necessarily, but should be viewed in the same level of seriousness as an unreasonable or unjustified use of force, which is the complaint that's being made, if that's the complaint that's being made, or if it's a complaint of a racist comment or a rude comment. It should, if you're supposed to record it and you fail to do so, well, the penalty is as though you've made a rude or racist comment.
And we shifted onto the broad shoulders of Assistant Commissioner Porter. It's years on now from the introduction of body-worn video. You've identified a significant reduction, I think you said, in the instances which are coming to the attention of PSC, where people are not switching on their body-worn video. Is that right?
Yes, that's correct.
What about where they don't? Her Honour's raising this issue because years on, broadcasts later, general awareness amongst members that they do have to do this and that it matters. What's the attitude of PSC now when there's a failure to switch on body-worn footage?
So, as I stated in my evidence on Friday, is every incident has to be assessed. Of course, there can be some issues as to why body-worn was not activated. Whether there's a technical issue or whether it's just in the circumstance they were unable to activate the body-worn. But everyone's assessed, but it starts at generally first strike, as in you get remedial advice, and then if there's repetitive behaviour, it goes right up to Part 4 action.
Because the first time might be from a very junior officer.
Yeah, that's correct.
On the learning.
Yeah. And generally we do get a couple of them, so when we have a new probationary member who's not experienced in the field, we do get the odd non-activation by them, and it's a learning curve for them.
Okay. But generally, do you accept the proposition advanced by Your Honour that other than that scenario, a failure to activate body-worn video, assuming that the technology is functioning, is a serious matter?
Yes, it is, and we have actually undertaken Part 4 action on a number of members of recent times.
We'll get you some data, Your Honour, and given the way things are going, might well be able to be provided to you through Mr. Porter before he finishes. I just raised the potential for equipment malfunction. Does that happen occasionally?
It does happen occasionally, yes. And also there's the issues of flat batteries, depending on
what's battery life of body-worn video?
It generally won't last 8 hours.
Right.
And so for members doing like for example, an overtime or a double shift, then the body one will generally run out of battery power. Unless they've had opportunity to recharge.
I'm going to move on to the other issue that Her Honour raised. I've put my sequence aside for now. It's best to deal with it while it's live. Her Honour's raised this issue of where there is a complainant's word against a police officer's word.
Yes.
Does that necessarily mean that the police officer's word is accepted?
No, it just, in those occasions, generally the outcome is it's unresolved because we cannot determine who is the correct version of events.
But what if there's information that suggests strongly that what the complainant is saying is right?
Then it will be put in the favour of the complainant, but it needs to have some sort of corroborating evidence.
Right. So does the inability to identify on the evidence which version is right mean that the police officer is exonerated?
Could you repeat that? Sorry?
Yes, it's perhaps important to try to get terminology right, isn't it? Because if there are two people saying different things, does that mean that the police officer has not done what the complainant alleges?
No, it does not.
What does it mean?
Well, Your Honour, with respect, this has been asked and answered. The answer was generally it leads to a finding that there's insufficient evidence.
So, is that the terminology that's used? I'm content with that. Is that the terminology that is used in the Professional Standards Command?
As in unresolved.
Unresolved?
If it's unresolved, we cannot determine whose version of events is the correct version of events, and as such, the allegation cannot be sustained or unsustained.
All right. Is there any other or fairer way of proceeding than reaching that kind of conclusion, assuming there's no corroborating evidence?
I can't see of any other way. Of course, it's all based on the available evidence.
Now, before we proceed further trying to pull together the strands of the evidence that you've given to Her Honour about the various complaints and issues which have come to light in respect of Mr. Rolfe's use of force, I'd just like to give you an opportunity to set out to Her Honour, please, what has occurred in relation to Mr. Rolfe's employment since the conclusion of the trial. I'm not asking you to give any sensitive health information in open court, but could you just let Her Honour know what has occurred in relation to his ongoing presence or absence from work?
As in current status.
No, starting at the end of the trial till now.
So he was acquitted on the 11th of March 2022 from the trial, and as such he was at that point in time suspended from duty because he was charged with a criminal offence. He had disciplinary matters that were ongoing or held pending the outcome of the trial. At the conclusion of the trial, the suspension, because he was under a criminal charge, was revoked, and then he was directed to take leave pursuant to Section 80 of the Police Administration Act.
And just explain why he was given a direction under Section 80.
Yep, so he was directed to take leave under Section 80 because he did have ongoing disciplinary matters which still need to be resolved. So he was directed to take leave at that point in time because he'd also had basically 3 years of accrued leave. So he's in excess of leave, so we used that instead of further suspending him from duty. He then undertook a period of personal leave over that period, but then we
Sorry, let me stop you there. So there's a period when he's directed under Section 80 because of pending disciplinary matters. And was that period of direction equal to his period of accrued leave from his 3 years of service?
No, it just continues until whenever the accrued leave runs out.
And so was the next development at the expiration of his accrued leave period?
No, the next development was he went on personal leave while he was on accrued leave.
Thank you.
But then he finished personal leave at that point in time, which was...
Let me stop you there again. Sorry to do this to you, Assistant Commissioner. Was that in relation to a personal health condition or another obligation in relation to a family member?
No, the only information we had at that point in time was that it was due to a medical condition. We do not know what the medical condition was.
All right, thank you. So how long did that period of personal leave for a medical condition last?
7 weeks at that point in time.
Right.
Then his medical certificate ran out. Then there was conversations with Constable Rolfe in relation to return to work. We wanted to try to return him to work, to integrate him back into the workforce. So there was a couple of meetings. So he returned to work on the 18th of July 2022, where at that period his direction to take accrued leave was revoked.
And what kind of work was he asked to do?
Yeah, so because he'd been out of the workplace for so long, he was put into administrative duties within the digital transformation group to assist with the electronic rostering project, where we needed members who have experience of rosters to go in there and assist with that project. There's also an opportunity for him to undertake the mandatory college online courses that he needed to do, which had expired whilst he'd been absent from work, and also to undertake catch-up and remedial training in relation to any changes that have come in since he was last at work. So he was only within digital transformations for approximately 3 weeks before he then went back onto personal leave.
And why was that?
Do not know. His medical certificate just saying that he had a medical condition.
Yes.
So that was on, I think it was 10th of August that he commenced personal leave again.
Yes.
He remained on personal leave right up until the end of January. And then, so when I say it was a personal leave, so in November, because he was ongoing personal leave, I instigated an independent medical examination.
Why did you do that?
Because we had no information as to what his medical illness was or why he was absent from the workplace. And he also indicated during his evidence in the inquest that when his medical certificate ran out on the 9th of December 2022, he advised that he would not be returning to work, but we had no information as to why he was not returning to work.
Right. Was he being specially singled out because he was Constable Rolfe?
No, he wasn't. I instigate independent medical examinations, I reckon 2-3 a week on average with members.
All right. So he had a medical certificate, and you asked that he attend an independent medical examiner to evaluate his medical condition. Is that right?
Yes, that's correct.
And was a medical certificate provided in due course?
A further medical certificate was provided for him to take leave from 9 December. It was a medical certificate advising that he was carer for a family member.
Right.
And that certificate was dated until the 30th of January 2022. 23.
And did a report come from an independent medical examiner?
Yes, so we received the report from the independent psychologist in December. As a part of that report, there was some matters that we needed further clarity on, so we then requested a supplementary report from that medical examiner.
And did you receive that supplementary report?
We ended up receiving that supplementary report on the 30th of January 2023, which is the day of the medical certificate expiring for Constable Rolfe.
So what happened after the 30th of January?
The 30th of January is the medical certificate ran out. Constable Rolfe did not return to work, but on result of the information provided from that medical examination, I implemented inability provisions under Part 5 of the Police Administration Act.
And what does that mean?
So I provided him a notice advising that it was my intention to retire him, and as part of that, also that was on the 6th of February, he was provided that notice, and then on the 7th of February he was provided a notice to stand down from duty pending the Part 5 action.
Now, why was he given a notice indicating an intention to retire him?
Yeah, so he was given a notice as per Section 87 of the Police Administration Act,
Yes.
where I formed the opinion that he had the inability to continue as a member of the police force.
To what extent was that decision informed by the information in the 2 reports from a psychologist?
No, it was fully informed by that assessment. Also, I had a risk assessment done by our Risk Management Internal Audit Division.
Was that because of the detail in the psychologist's reports?
Yes, it was.
All right. So on the basis of those, the decision was to give him a notice of intention to retire him.
That is correct.
And have there been developments since that time?
Since that time, Constable Rolfe has been issued a Section 79 notice for, as we all know,
the essay of
the
2,500 words.
yeah, the opinion piece.
And that was on the Sunday, not yesterday, but the week before. Is that right?
That is correct.
And that required him to provide an explanation for, in essence, why he'd written the essay and published it.
That is correct.
And did he provide a response to that within the 7 days?
It was due yesterday, but there was a extension given for an extra day to his legal representative.
Thank you. And on the basis of whatever information is provided by him, will there be further consideration given to other steps that might be appropriate?
Yes, it will be depending on his response.
Now, one of the things that Mr. Rolfe has at times expressed agreement about was what he says is an instruction that he not attend police premises. Do you know what is referred to when I identify that issue?
Yes, he's referring to the conversations had with myself and also the Director HR at the time in relation to his return to work plan, and there was also a letter provided to him, I think off the top of my head is around the 14th of July, he's provided a letter in relation to his return to work.
Right. And so what's the issue with his coming back to police premises?
At that point in time, because he hadn't been in the workplace for so long, and the ongoing inquest, a determination was made that he would undertake administration duties, and he was given a workplace to undertake those administration duties.
Good.
He was not completely banned from the police stations, because it was advised to him in that letter that if there was a need for him to attend the police station, that he just discuss it with his executive member that he was nominated, who's also his return to work manager, Acting Commander John Atkin, so that access could be facilitated.
Given the kind of administrative work that he was doing, was there any particular reason for him to attend police stations?
No, there was not.
Again, was he singled out, or was any punitive action taken against him because he was Constable Rolfe?
No, he was not.
I'd like to come back now to the evidence that you've given to Her Honour about the various matters that have been raised against him and which are summarised in the summary document of 10 pages. I'm not going to go through all of those again, but I'd like to ask you some questions about use of force. How many use of force?
Sorry, go on.
How many use of force forms do you understand Constable Rolfe to have completed during his years of active service?
Yep, so every use of force was reviewed by Senior Sergeant Barham. I believe there was 46 in total. So that's 46 use of force reports in 3 years of service.
Based on all of your experience, what do you make of that number?
No, that's not a high level number. That's really only working on 1 a month, and that's not extraordinary for a frontline officer.
And where was he principally working?
I'm frontline in Alice Springs.
Is the raw number of use of force forms completed by a member a helpful indicator of whether they're using excessive force?
And no, it's not. And if we have a member who is doing the right thing and reporting appropriately his use of force, because use of force, it is used for anything that is not a normal escort hold. So any force that you undertake, that's not just a normal escort hold or using handcuffs just for an escort or for searching. There's a requirement for members to provide or submit a use of force report.
So, for instance, if there is a standard arrest which results in a person having handcuffs placed upon them, does a use of force form have to be completed?
It depends on the circumstances, but if the person's just been arrested and then is compliant with handcuffs being placed on just for escort purposes or for searching, there is no requirement for a use of force. But if there is a physical altercation or the person has been ground stabilised and handcuffed, then yes, there has to be a use of force report.
Now, you've told Her Honour about a number of instances where complaints have been made, or whether as a result of this inquest or as a result of the analysis of Senior Sergeant Barham, or through other reasons, an issue has arisen as to whether Constable Rolfe has used excessive force, correct? A number of reasons why matters have been reviewed by PSC and by yourself.
That's correct.
Now, how many of those occasions have yielded an actual or potential determination that Constable Rolfe used excessive force?
None.
What about...
Well, oh, sorry, as in, there is the potential as in, but as an actual part 4 outcomes, none.
None in relation to a Part 4 outcome. That is that partly because on occasions Part 4 was not available because of the Section 162 limitation period having expired?
Yes, that's correct.
Let's go through the ones though where, in essence, there either has been an evaluation that excessive force has been used, or there might be in due course, all right?
Okay.
First of all, I think you've told us the 3, but you correct me if I'm wrong there. There's Master TG.
That's correct.
Is that one where the view of yourself is that excessive force was used in the removal of Master TG from the rubbish bin?
Yes, that's correct.
There's the Araluen Park incident with the 2 intoxicated males who were pushed over.
Yes, that's
Again, is that a case where there was a decision, not pursuant to Part 4, but generally, that excessive use of force was involved?
Yes, that's correct.
And there is the Albert Bailey matter, which is as yet unresolved. Is that right?
Yes, that's correct.
But where there are concerns which need to be resolved by fair process.
That is correct, yes.
Just want to go through the dates of those 3 matters then. With Master, and you can use the 10-page document if that's acceptable to Her Honour for that purpose.
Yes, I'm not sure.
Thank you. Master TG is on page 3 of that. The incident occurred on the 11th of August of 2018, is that right?
Yes, that's correct.
And then there's been a process that Her Honour's been told about with the analysis and communication from Sergeant Bayliss to the Ombudsman coming back to Professional Standards Command, but then through the processes of this inquest, a further review being done by PSC. Is that so?
Yes, that's correct, Your Honour.
And that took place not before the Uendamu incident, but during 2022.
That is correct, Your Honour.
So that wasn't one where there'd been an adverse decision about his use of force prior to the tragic events.
Yes, that's correct.
Let's go to the next one on that page. That's the Arrowland Park one. That was an incident that was in 2019, the 18th of February, is that right?
Yes, that's correct.
And Mr. Barham identified that in his review in March of 2020.
That's correct, yes.
And then ultimately on review, you have agreed with the analysis of Senior Sergeant Barham.
That is correct, yes.
And again, when was that position on your part?
That was in 2022.
I think that's when the remedial advice was given. When was the PSC review done?
2022,
All right.
I believe.
Just check your
I'll have to
your final column there. I just want to make sure we've got it right for Her Honour.
Oh, sorry, that's when PSC reviewed it.
Yes.
But it was, I've done a further review since then where,
Yes.
where I then gave remedial advice to
Yes.
Sergeant Robert Kent.
Right. And oral remedial advice was given to Mr. Hanson, and Mr. Rolfe has also been communicated with. Is that right?
Yes, that's correct.
All right. So again, as of the date of the tragic incident, had there been resolution of matters by PSC?
No.
Right. Now I'm going to ask you about Mr. Bailey, but we'll keep that very short because it's not appropriate to go into detail with something that is not resolved finally as yet. But if you go to page 7, that's a useful way of going about it. That was an incident that took place on the 12th of October of 2019, I think. Is that right?
Yes, that's correct.
Now, Mr. Barham, it was identified, I beg your pardon, there was an identification of a potential issue in relation to the use of force. We'll keep it to just Mr. Rolfe for these purposes. But that was on the around the end of January of 2020. Is that right?
Yes, that's correct.
And then in due course, Senior Sergeant Barham expressed his views about the excessive, what he said was an excessive use of force. Is that right?
Yes, that's correct.
And the issues are yet to be finally resolved because of various processes that are taking place that Her Honour knows about.
Yes, that's correct.
Right. Now I'm just going to whip through the other ones to try to put this into perspective. There's the Bojangles matter from 2017. So it's just on the first one. The view of PSC ultimately is that there was not excessive use of force. Is that right?
That's correct.
There's the Malcolm Ryder matter.
I'm not sure that's the view.
Oh,
The
big pardon.
view is that it's not possible to determine.
Whether the force was
I take your
excessive.
response. So not possible to determine, so no adverse finding.
Yes.
That's perhaps the most accurate way for
That's
me to
correct,
put it.
Your Honour.
Then there was the Malcolm Ryder matter. That was in early 2018.
Yes, that's correct.
Now, ultimately, there was perhaps we'll put it the same way again. It was not possible to determine whether the use of force by Ms. Constable Rolfe was excessive. Is that right?
On the evidence that PSC gained, yes, that's correct.
The remedial advice about other matters was provided. We've spoken about Gibbs, Master TG, and we've spoken about the Arrowland Park incident. Then going to, I think it's Master CW. Master CW. That was at the start of April of 2019. And once again, and we can do this with the Madrill matter. Both of those matters were in April, and on both occasions, was it not possible to determine whether excessive use of force had been utilised by Constable Rolfe?
Yes, that's correct.
The perjury matter we can perhaps set aside for this purpose. there's the Chris Walker matter, which was in June of 2019. Now, how would you characterise the finding from yourself and PSC in respect of that matter?
Our finding there was that the application of force was appropriate, reasonable, necessary, and proportionate in the circumstances.
Right. So that's if you like a positive finding rather than the other category which we've been utilising previously.
Yes, that's correct.
All right. Let's move to Antonio Woods, which is a June 2019 matter. How would you characterise the ultimate finding by PSC there? This is the tripping and falling, and the allegation by Mr. Woods that he'd been kicked in the head 6 times.
Yes, no, we found that there's no evidence of excessive use of force undertaken by Constable Rolfe.
So again, if we refer to that as a positive finding, which is a bit of an unsatisfactory way of putting it, a positive finding that excessive force was not used.
That is correct.
Is that right? Okay. Then there's the Todd Tavern matter. You've given evidence to Her Honour about that. That was just shortly before the tragic events. That was in September. And ultimately, in reasonably recent times, your decision after viewing the footage and going through all of the evidence was, again, I think a positive finding that excessive force had not been used by Constable Rolfe.
Yes, that's correct, but we determined that he could get remedial wise to consider further options.
I'll go back to it. My learned friend, Mr. McMahon, has raised a matter with me, and I'm happy to deal with it. Go back to Mr. Woods, if you don't mind.
Yes.
That's the incident involving 6 kicks to the head alleged by the complainant. The initial investigation found insufficient evidence to determine if force was excessive, but you've ultimately, on review, made a positive finding that the force used was not excessive. Is that right?
Yes, that is correct, taking into account all the other information from the custody assessment, the nurse assessment, no medical evidence, no injuries.
Mm-hmm. So there's been an adjustment of position from insufficient evidence to determine if the force was excessive to a positive finding that the force applied was not excessive.
That's
Is that right?
correct. That is correct.
All right, thank you. So that takes us to the bailing matter, which arose on the 12th of October of 2019, and of course that's an ongoing matter. Is that right?
That's correct.
And then there are the Uendamu matters, which have resulted in action being taken as set out in the table. In other words, remedial advice in respect to a variety of things. Time having passed since the incident during the murder trial and similar.
Yes, that's correct.
And the other matters I won't go to, Your Honour, because they're not use of force matters per se. So in those circumstances, was there any adverse decision about Constable Rolfe's use of force that had been made by the time of the tragic events?
No, there was not.
But there were a number of matters which were such as to arouse concern about the way in which Constable Rolfe pursued people, communicated with people, and potentially used force.
Yes, and as well as non-activation of body-worn video.
Yes, absolutely. So, what do you say about how those various issues were dealt with by the Northern Territory Police Force prior to the Uendamu incident?
So, it was identified by the Professional Standards Command of those issues starting to arise, and Detective Superintendent, or at that stage, Acting Commander, Virginia Reid, advised the Alice Springs Command Management Team of the concerns that they were starting to see.
Right. So there was advice about issues that seemed to be emerging.
That's correct.
Right. Should more have been done, or something different have been done?
No, at that point in time, it was raised because that's the purpose of command management team. Is if there's any concerns that are being identified regarding a member within that command, it is raised with the management team to take whatever action that they require to address those concerns.
So what was done?
So it was referred to, like I said, the command management team by.
Do you recall the date or approximate date?
No, it's in my affidavit, Your Honour. I can't remember the paragraph.
Is this paragraph 102 in your first
Yeah,
affidavit?
102, Your Honour.
Thanks.
So there was it was raised with the commander of Southern and the superintendent of Alice Springs,
June 2019.
June 2019. Yes.
That is correct.
And there was a further discussion which took place with the then acting commander of Southern in July of 2019. Is that right?
Yes, that is correct.
That was particularly about the issue of body-worn video activation, generally at Alice Springs, but specifically too about Constable Rolfe.
That is correct.
And there was a third conversation in October of 2019, which you detailed there.
And just before we go on, I just note from Virginia Reed's statement, 7-115, paragraph 10. She notes that it was about this time, and she's talking 12th of June 2019. She spoke to Commander Curry and Superintendent Vickery during a command management team, advised them I was reviewing a number of complaints referred to me from the Ombudsman Office, when Naja had raised concerns with the complaint outcomes and it was likely they would be recategorised and further investigated. I further conveyed that I was concerned about Constable Rolfe's non-adherence to the body-worn video policy, and that this was the third occasion that I had become aware of people fleeing from him and injuries occurring when apprehended. That was June 2019.
Thank you. Now, what do you say in light of those various analyses being done by all of them senior members about the follow-up and the sufficiency of response?
Could have been done better.
What does that mean? Should it have been done? It obviously could have been done differently. Should it have been done differently and better?
Yes, I believe it should have been.
Right.
Because there had been previous stuff sent by Superintendent Vickery or conversation with Constable Rolfe by Superintendent Vickery.
I'm going to refer to the single page document now. It's actually 2 pages, it's a front and back. Do you know what I'm referring to if I describe it
Yes,
in that vague way? Now this gives a listing of the remedial advice to Constable Rolfe in relation to a variety of matters, including non-activation of body-worn camera. Is that right?
Yes, that's correct.
And we can see that that there were various forms of advice, but let's have a look at the dates together if you don't mind. There's an email from Superintendent Vickery on the 5th of March 2018. There's a conversation involving Senior Sergeant Ball in February of 2018, is that right?
That's correct.
And there's a reminder by Superintendent Vickery in April of 2018.
Yes, that's correct. And then after it was brought up to CMT, is our understanding that there were dip tests of body-worn video undertaken by Superintendent Pauline Vickery.
I'm going to stop you there. What's a dip test?
So going into Axon, looking at body-worn. So going in Axon, looking at jobs that Constable Rolfe attended and looking at whether the body-worn had been activated and downloaded onto Axon.
Yeah.
And then doing a dip test of review of that body worn on our Axon database. to
So
ensure.
if we describe that instead of a dip test as an audit,
Yeah,
would that be accurate?
yeah,
Okay.
it is. It's an audit.
Okay. And then you have recorded in this sheet that remedial advice was given in October about in respect of the Malcolm Ryder non-activation body-worn camera. It's the 5th entry.
Yes, that's correct.
So it's referred to as given on the 4th of October and the 5th of October. Was that essentially the same thing being administered?
Yes, so that was remedial advice. It is the same thing as being administered as a remedial advice, yes.
So there are 5 separate occasions when formal communications of different kinds, email, conversation, reminder, and remedial advice were administered to Mr. Rolfe during 2018.
Yes, that is correct.
All of them about non-activation of his body-worn camera.
Yes, that is correct.
And then ultimately there were further examples of remedial advice given, but they were last year.
That is correct.
Right. So when you look back at that, recognising that whatever else he might or might not have done during the tragic incident, he did operate his body-worn footage. Yes?
Yes.
What do you say about the sufficiency or otherwise of the response of the Northern Territory Police Force to the various examples of Constable Rolfe turning on his body-worn camera?
Still believe it could have been done better.
Should have been done better?
Should have
Sorry,
been done
impressive.
better. So I'll give example, the remedial advice that was back in 2018 in relation to those first 3,
Yes,
that was never reported to PSC or recorded on IRPro, and it should have been.
right. Now today, is it likely that it would be reported and recorded on iPro?
Yes.
And there are various other issues about which he was provided with remedial advice in relation to the operational safety principles, but that's going to happen upon his return to work.
That is correct.
And if he comes back to work, likewise, he'll be given remedial advice about the need for minimisation of force and adherence to a tactical operations model.
Yes, and the proper use of the tactical operation.
Yes.
Tactical options model.
Options model. Thank you, I said operations, I think, didn't I?
You
I beg
did.
your pardon.
You
Options.
confused me there.
That's my fault. But he has been given remedial advice already in relation to Master TG.
That is correct.
He was counselled in relation to not submitting appropriate reporting in respect of the Ryder matter.
Yes, in relation to a custody illness injury report or incident injury report.
And there are various other matters arising out of the tragic events at Uendamu, is that right?
That is correct.
And those will be administered should he return to work.
That is correct.
When you look back, how would you characterise the cooperation of Constable Rolfe in relation to his body-worn camera obligations during 2018?
Now, his performance 2018 was fairly poor.
Right. And if that happened today, if somebody did that repeatedly in 2023, you said if they're early on in their career, they'd be quietly given some guidance. But if they kept doing it in an intransigent way, what would happen?
Now, he would have ended up having Part 4 action.
And that's what should have happened back in 2018 as well.
Yes, on the pretty well the 3rd account.
Excuse me, just a minute. I don't want to go over what you've said already, but at paragraphs 181 and following of your first affidavit, you say in paragraph 181, it is apparent that some of Constable Rolfe's supervisors and peers either condoned or overlooked his poor behaviour. This is not consistent with the values of the police force and is not acceptable. And what did you mean by that?
Because some of those incidents that were reviewed after the fact, so reviewed by Senior Sergeant Barham and also reviewed by PSC, is there were supervisors who found the use of force in those circumstances to be appropriate and justified, and on review of those incidents they weren't, and so the supervisors should have recognised that and dealt with that.
And again, has the message been given as best can be done, clearly, that supervisors are obliged as part of their duties to do better and differently from what happened in respect of Constable Rolfe?
Yes, I have. It's also been put out through broadcast as well as guide templates or sheets for doing assessment of use of force, and it is also forming part of the Sergeant Development course, which the first course kicks off on the 13th of March.
I'm not going to ask you in detail about the content of various communications that have been identified on Constable Rolfe's telephone, because there are legal issues which have been placed before the Supreme Court on an application for judicial review. All right? However, one of the things that Constable Rolfe has said, we know from his essay amongst other things, about those messages is that they were intended to be private between him and various other officers. Now, is that, in general terms, an acceptable excuse for using racist, sexist, homophobic, disrespectful, misogynist remarks in communications to another police officer?
No, it's inappropriate. It's not in line with the code of conduct, where you have to abide by the code of conduct at all times, both on and off duty.
And has a broadcast force-wide been sent out to address that issue specifically?
Yes, I believe so. I can't remember the specific date, but there was one sent out.
Okay. That was referred to by Deputy Commissioner Small-Patch.
Does the code of conduct specifically refer to racism?
Yes, it does, Your Honour. It talks about racism, discrimination, and other things.
And is there also reference elsewhere in force policies to the need for respect and inclusiveness in dealings with anyone?
Yes, it's in our respect, equity, diversity policy.
And for how long has that been in force? I won't pin you down to a
No,
year.
it's been a long time. It's been in a long time. I can't remember the date, but it's been in for quite a while. And as part of that also, every member of the police force undergoes respect, equity, diversity training, and they also have to complete a mandatory biannual, or every 2 years, they've got to complete a mandatory refresher of the respect, equity, diversity policy and the requirements.
I'm reminded that reference to the broadcast is to be found in paragraph 66 of Mr. Small-Page's third page. And you probably heard evidence this morning about issues to do with systemic racism and arguments that it would be useful to engage with whether anything done or not done in processes within the Northern Territory Police Force should be reflected upon in terms of whether they constitute systemic racism. Did you hear that evidence?
Yes, I heard that evidence.
Now, as an Assistant Commissioner of the Force, is that an issue with which you would be prepared to engage and to have further discussions with this morning's witness?
No, there's full merit in undertaking that sort of work, because we all have a broad understanding of what systemic or institutional racism is. It is different to your interpersonal racism, but if there are any systems or processes that we have in place that do disadvantage anyone in our agency, it should be looked at, yes.
And are you,
And you see the benefit of someone from outside the agency adding perhaps no matter how objective you try to be within your own agency, but an outsider can have perhaps another perspective and perhaps a more objective perspective.
Yeah, and that's correct, Your Honour, and it is my understanding under the Aboriginal Justice Agency, because my Deputy Commissioner, or one of my Deputy Commissioners, Michael Murphy, is the NT representative on that governance committee, is that one of their roles is they are examining all NTG public sector organisations in relation to systemic racism. I believe that they've already done an audit on DIPL, but they will be looking at us in the near future.
and is the Northern Territory Police Force prepared to be open and to discuss those issues?
Yes.
Your Honour, I referred to the respect, equity and diversity policy that's to be found in the third of Deputy Commissioner Small-Page affidavits.
Thanks.
As MS3. Now, an issue that's been raised is whether, in all the circumstances that existed at the relevant time, Constable Rolfe should have been a member of the IRT, given the specific provisions in the SOPs for the IRT about that matter, and I think you refer to this at paragraphs 105 and following and 151 and following of your first affidavit. Let's go to 105 first. There's an excerpt from the relevant provision of the standard operating procedures for the IRT there. Is that right?
Yes, that's correct.
And so there it says if members who are the subject of disciplinary action will be stood down during the investigation or subsequent penalty period at the discretion of the Commander, Southern Command. Now, to cut through this, was that the situation with Constable Rolfe in the period leading up to the tragic incident?
Constable Rolfe had no formal disciplinary action ongoing at that time.
Should he have, however, been subject to disciplinary action? Given CW and LM and the fact that he failed to activate his body-worn video on 2 further occasions in 2019?
Yeah, well, all I know, Your Honour, is he didn't have any disciplinary action pending. There's investigations ongoing at that time. And the commander of Southern Command was fully aware of those matters because they all form part of the command management team meeting, and so ultimately it was a decision of the commander of Southern Command whether Constable Rolfe remained on IRT or not.
But given the 5 warning or 5 responses to failure to use body-worn video in 2018 that we've referred to, and the fact that that on the 2nd of April in 2019 there was a complaint in relation to CW, and that complaint also involved, or the incident also involved, a failure to activate body-worn video.
Yep.
You're up to disciplinary action, aren't you?
Yes, so as I highlighted before, Your Honour, those first 3, PSC were not aware of that remedial advice from Superintendent Vickery or Senior Sergeant Gall.
But they should have been.
They should have been. the two that were given in October related to the one matter involving Malcolm Ryder. So technically at that point in time at PSC,
There's also the one given on the 26th of July.
oh, that's 2022,
Oh,
you're
that's
right.
2022, sorry. Sure. So PSC are aware of one, but they're raising it, well, I'll take that back. But in fact, there were 4. And then we have the 1st of April 2019.
Yes, that's correct.
So if everything had been working as it should have been,
There should have been this serious consideration. This reaction should have been commenced. So it should have been a serious consideration by the commander, Southern, if everything was working as it should at that time.
There was a. Oh, sorry. No.
sorry, the timing's bad.
No,
But
no,
the same applies when we take into account the 20th of April 2019 incident and a non-use of body-worn video. It wasn't identified until the 14th of October, but had everything been working as it should have been, this would have been the 6th.
Yes, that's correct, Your Honour. It definitely would have been part of our actions for that many non-activations.
There was on the 30th of October 2020 what is described as a critical decision of Professional Standards Command. This is to be found in the first exhibit to your first affidavit. So BPO1, right? Do you know what I'm referring to here?
Yes.
Assistant Commissioner?
Yes, I know what you're referring to.
This relates to a meeting held on the 30th of October involving yourself, Assistant Commissioner White, Assistant Commissioner Antisich, and the Acting Senior Director of Legal and Strategic Policy. Going particularly to the third of the decisions, what was determined on that day?
Just the third decision?
Yes, let's focus on that one.
Yep, so the decision was that at that point in time there was no barriers to preclude Constable Rolfe and others for incidents that they were involved in that it was separate to the criminal matter being dealt with, re the Yundamu matter, and that under Part 4 of the PA and requirements of the Ombudsman's Act, that they could be spoken to in relation to those matters.
All right, so that was a formal decision, in effect liberating Professional Standards Command to investigate matters other than the Yundamu incident.
That is correct.
But of course, it was inappropriate, and this is where the first of the decisions come in, that Constable Rolfe be interviewed in relation to that, given that there was a homicide trial in it.
That is correct.
Now, so that's 30 October. Was another decision taken in March of 2021?
Yes, it was.
Now, between those two dates, namely between October and March, had there been correspondence between PSC and the legal representatives for Constable Rolfe?
No, the correspondence actually started back in August before that critical decision.
For October, right?
Yep, so back
Just
in August.
summarise in general terms. We
Yep,
don't need to know each
so
one.
there was correspondence between Professional Standards and legal representative for Constable Rolfe in relation to the need to interview Constable Rolfe for a number of outstanding matters. I believe there were 7 listed within the correspondence. There was backwards and forwards between the both parties. And as a result of that back and forward, then that critical decision was made, because one of the matters listed originally was the Yundamu matter. Then that critical decision was made, correspondence continued, which resulted in legal representative writing direct to Commissioner Chalker in relation to the lawfulness and what is right in relation to interviewing his client.
And is that in March? We reached March of 2021 by this point?
Yes, I believe that was 5 March that letter was sent to the Commissioner. Then there was a meeting held, so that was referred to Deputy Commissioner Smallpage.
All right. And in essence, what position was adopted by Deputy Commissioner Smallpage in light of the correspondence from those representing Constable Rolfe and the serious concerns raised on Constable Rolfe's behalf about the impact of interviewing Constable Rolfe about other matters when the murder trial was at hand?
Yes, the decision was made that Constable Rolfe would not be interviewed in relation to any matter due to the criminal trial active.
So priority was given to the criminal trial matter as against continuing investigations in relation to disciplinary matters.
Yes, that is correct.
And did you and PSC comply with the Deputy Commissioner's instruction?
Yes, we did.
And do you stand by that as an appropriate response?
Yes, I do.
Why?
An assessment was undertaken of a number of the investigations. It was determined that there was likely not to be part for action on most of them, and the criminal trial was taking precedence over anything else because it was a very serious matter involving the member involved, and we did not want to jeopardise any judicial processes.
I'd like to take you to paragraph 48 of your third affidavit, please. This falls under the heading Improvement in Practices.
Sorry, could you...
Paragraph 48 of your
Thank
third
you.
affidavit.
Thank you.
Just like to make sure that you said what you want to say in relation to the missed opportunities that existed to address behavioural concerns in respect of Constable Rolfe.
Yes.
Is there anything you'd like to add to what you said already in that regard?
No, I don't think so.
Thank you. All right, let's go to the final matter then, please. I'd like to ask you just a small number of questions about what's called the Galliot report. You're closely familiar with that.
Yes, I am.
The Commissioner has accepted in principle all of the recommendations from Commander Galliot.
Yes, that's correct.
What is your view about the Galliot report and its utility to your force?
I think it was a review that was needed to be undertaken.
Yes.
Because it is pretty well recognised that the current complaint discipline system is not conducive to a modern police force. It was an independent review, so it was Mark Elliott's own review, but there are a lot of things in there that will drive positive change for the organisation in relation to, especially in relation to the structure of the Professional Standards Command, and also new processes that will have a more focus on development and managerial intervention with members rather than formal discipline processes.
Okay, I'd like to come to some matters which have been raised by Commander Galliot, but also in an affidavit from Marcel Delaney of Naja in a document from 28 February of this year. Ms Delaney has done an analysis of delays in relation to the completion of complaints, and in essence has said that first of all, matters are finalised too slowly. What do you say about that?
I agree, some matters are finalised too slowly.
Why are things too slow?
There's a variety of reasons.
Tell Veronica about that, please.
So I'll give an example for just a minor complaint which is dealt through the complaint resolution process, which should be dealt with immediately. There's a change in process with the Ombudsman's office, whereas initially the supervisor could deal with that matter in the field on receipt of the complaint, so deal with it then and there. Whereas a change by the Ombudsman's office that has to be categorised before it can be dealt with, so the report would be taken from the complainant, sent through the Professional Standards Command, then it'd go through to the Ombudsman's office for categorisation, then it'd come back through as a complaint resolution process matter, they go back out to the command, and then the issues that were faced is the ability to then find complainants to resolve those matters which could have been dealt with on receipt of the complaint then and there. There's also some of the issues re delays is at the time with Category 1 and Category 2 investigations is there was significant delay on a number of matters due to the COVID emergency, as in PSC staff were moved away. Also, those who were allocated investigations were undertaking other duties in relation to COVID response and not actually doing the investigations as required. There's also certain delays when it comes to freedom of information applications. So at times NARJA will make a freedom of information application to get information through either body-worn video, promise records, any CCTV, or whatever, to support any complaint that they wish to lodge. And so there are delays in relation to that space. A lot of them can be delayed due to there's an ongoing criminal investigation that it may prejudice through the release of any FOI and those type of things.
One of the other matters that she raises is how findings are made. And she raises various issues. I've done one of those curious mistakes because too often males impute decisions to a male when they're in fact a female. I seem to have done the reverse, and I apologise for that. I'm told that Marcel is a male, so I'm sorry. But Mr. Delaney has also criticised how findings are made by Professional Standards Command. Do you have any response which you wish to make in that regard?
No, the findings are detailed. There's 7 actual agreed or approved findings that are within the police complaints agreement. PSC, on whenever they go through the evidence, match that evidence against what is written within those findings within the police complaints agreement.
Are there problems with the architecture of the process as set out in the police complaints agreement? That's another issue which Mr. Delaney identifies.
Yeah. Not that we've identified, and that's, to be honest, that's the first time I've actually heard that there were issues in relation to those findings.
And you've given, I think, the answers you want to provide in relation to an unresolved finding or an insufficient evidence to sustain the allegation finding. Is that right?
Yes, that's correct.
All right. What Mr. Delaney says, to summarise in paragraph 27, is that the effect of strict compliance with the categories is that many of our clients' complaints must be finalised as unresolved or insufficient evidence to sustain the allegation unless there is unequivocal evidence arising from body-worn footage. What do you say about that?
Yeah, I'm actually confused as to what he's actually saying there, because
I
the
think
finding's different to a categorisation.
The bottom line is that not many complaints are established. especially when there's no body-worn footage to resolve things one way or the other.
Yes, that's correct, and as I stated before, we have to go on the evidence to make a determination. If we don't have the evidence to determine whether the complaint can be substantiated or not substantiated, then it remains unresolved.
Now, Commander Galliot has recommended a variety of changes to the Police Administration Act and to processes so that less serious matters are dealt with quicker at command level, but more serious matters remain under a new version of Part 4. Are you in agreement with that approach in general terms?
Yes, in general terms.
He's identified some problematic limits in terms of resourcing of Professional Standards Command. Do you identify an issue there?
Yes, I do, and I highlighted in my evidence of Friday the changes in resources and what we actually do need to move forward.
And that incorporates having an Assistant Commissioner specifically dedicated to Professional Standards Command.
That is correct, to drive all new continuous improvement initiatives and to have that face-to-face and close contact with key stakeholders to actually drive our continuous improvement.
Are there any other issues which you would like to identify to Her Honour about the Galliot report?
It's going to take time. It's going to take a lot of consultation with a lot of stakeholders to determine the ability to progress some of those recommendations, especially when it comes to legislative change, when there's legislation that's owned by others. So there'll be a need for a lot of consultation in relation to some of those initiatives or recommendations that have been put to the North Edge Police Force to consider.
However, are you and the Commissioner committed to reform of the processes broadly in line with what's been recommended by Commander Galliot?
Yes, we are.
Now, so to conclude the questions from me, I think there was something that you wanted to communicate to the court and to the family of Kumanjayi Walker in relation to your own response to the tragedy.
So just from a personal perspective and on behalf of the North Edge Police Force, I do want to pass on my condolences to the family of Kumanjayi Walker and for the ongoing stress that is created going through such a long drawn out process. And I also want to pass on my condolences to all those others involved, including the Department of Health, the nurses of the Department of Health.
And what do you say about your own commitment to reform, to take account of what is being learned in the course of this inquest?
Well, I've always been fully committed to everything to improve the North Edge Police Force. It is recognised that we could have done better and we can do better, and that we are really pushing to increase our Indigenous or Aboriginal employment within the agency. They are part of our family, and we need to do everything that we can do possible that is right to have that engagement and interaction and agreed understanding with the community that we serve.
Thank you, Your Honour. Would this be a convenient time for a short break?
Thank you.